Okay, here we go. We're now on Chapter 10. We're going to be looking at torts, which is the other major topic for most legal courses, contracts and torts. What is a tort? A tort is a civil wrong other than a breach of contract, which we talked about last week. Tort law limits how people can act and use their resources. So a tort law says that you can do certain things and you cannot do certain things. And it basically comes down to whether or not you are injuring somebody. There are different categories, three primary categories: intentional, which I'm going to talk to in Part A here; negligent, which we're going to talk about in Part B this week; and strict liability, which we'll cover in a Part C. So, intentional torts. It is a deliberate action that causes injury. Pretty straightforward. This is not criminal action. At the end, we'll talk about the difference between torts and criminal. These are civil actions when one party injures another one. The deliberate action can either be a desire to bring about certain results, or they can be substantially likely. So you don't have to show that it is always going to bring that, but it would be substantially likely. That comes into effect especially when we look at negligence on the next video. Okay, different types of intentional torts. Assault and battery. We're going to see in a minute that those are actually two different torts, one of assault and one of battery. Intentional infliction of mental distress. There's a couple of interesting cases in the book on that. Read about invasion of privacy. I'm not going to cover it on this lecture. False imprisonment and malicious prosecution. We'll talk a little bit about false imprisonment since that's a pretty important tort for retail businesses. Trespass, look at it in the book. Conversion, look at it in the book. Defamation, I'm going to cover real quickly and just give a quick definition of it so that you know what it is, as well as fraud, and then a quick discussion of intentional interference with contractual relations, a common law business tort. Okay, the key in looking at the tort is to carefully read the definition and know each element of the tort. If an element of the tort is missing, you do not have a tort action. Cases are determined on the jury's factual determination that all elements are present. This is where the job of the jury comes in. We've said they determine facts. Well, what they have to do when there is a tort in front of them, the judge will give them a definition of the tort. It'll break it out into 1, 2, 3, 4, 5, what all the elements are, and then it's up to the jury to determine factually that those elements are present in that case. Here's an example. Let's look at assault. Assault is a threat of immediate harm. It's any action that arouses a reasonable apprehension, a fear of immediate harm. So if I'm at a party and I end up antagonizing some guy that's there, and he comes by and he gets very angry and he starts shouting at me, and he says, "I'm going to go home and get my gun and come back and shoot you." Well, there's certainly a threat there. Is there a reasonable apprehension? It's certainly a threat of harm. Is there a reasonable apprehension? Well, you know, I've heard that this guy's related to some gang guys, and yeah, I'm really apprehensive about it. But it is of immediate harm. No, he's going to go home and get the gun and come back. So there really is no assault that takes place. Also, it has to be reasonable apprehension. That 98-pound weakling that comes up to me may not reasonably cause me apprehension if he threatens to pound me into the sand. But if Arnold Schwarzenegger, at least the Arnold Schwarzenegger of 20 years ago, comes up to me and threatens to pound me in the sand, that's a reasonable apprehension. So that is an assault. It is a threat of immediate harm. A battery is an unauthorized, harmful, or offensive physical touching with another person. So all three elements must be present for a battery to occur. And so if I'm in an elevator and people are pushing against me, it may be offensive, it's unauthorized, it's a physical touching, but it's not the purpose of the person that is doing it. It just happens because of the circumstances. The battery does not require the direct physical touching of two people, i.e. somebody can throw a rock or shoot an arrow. They can put poisoning in a drink. or they can think they're funny and pull out a chair. It's taking something away rather than striking. And those can all be batteries. An important aspect, and these come out of common law, out of cases where these things happen. A case comes up and somebody says, well, it was an unauthorized, harmful touching, but then the defense lawyer says, well, they didn't touch him, Your Honor. He threw a rock and hit him. And then they came by and said, okay, well, throwing a rock is the same thing as battery, or they poisoned them. And so these things kind of develop over time. And likewise, the doctrine of transferred intent. This is when the transfer of intent from the target to the accidental victim. There was an intent to unlawfully or wrongfully physical touching or hitting them with a rock. Throw a rock at the person next to me and they hit me, I still have an action against that person, even though they did not intend to hit me. It was a doctrine of transferred intent. Okay, what about intentional infliction of emotional distress? That is the outrageous and intentional conduct with a strong probability of causing mental distress to the person at whom it is directed. This comes up in a business setting sometimes when employers fire people. They at times will say that they have been intentionally, the employer intentionally inflicted emotional distress. Look at the Van Stan v. Fancy Colors and Company, case 10.1 on page 283. Its citation is 125 F. 3rd 563. It was the 7th Circuit in 1997. The first couple of paragraphs give a couple of good definitions of what intentional infliction is. But on page 284, there's an interesting description under Pavilion v. Cafferly. Quote, the employer, knowing that the plaintiff was susceptible to emotional distress, offered her money for sexual favors, fired her after she refused, and after he fired her, threatened to kill her, to rape her, and to file a legal action challenging her rights to custody of her child, and attempted to disrupt her new employment relationship. Now, when you hear that, there's just this sense of, that's outrageous. That is what intentional infliction of emotional distress requires. Outrageous action by an employer. Take a look at that case and read it through. I think you'll find it interesting. Okay, false imprisonment. False imprisonment is the intentional confinement or restraint of another person without authority or justification and without the person's consent. So merchants have protection statutes. They allow merchants to reasonably stop suspected shoplifters. See Colonial Stores, Inc. v. Fischel, false imprisonment case. You have to look at this, and sometimes the things that these stores do are pretty outrageous. Other times they're just trying to protect their right. A store does have a right to hold a person if they reasonably suspect them of being a shoplifter, but you better do it very carefully and make sure that you are not exceeding the statutory right that you have of it. Okay, defamation of character. Again, these are all intentional torts. These are things that people intend on doing. The defendant made an untrue statement of fact, not the person's opinion, that the statement was published to a third person. By published, we do not mean it was published in a magazine or something. It means it was told to, either in writing or orally. Slander is defamation, is verbal defamation, and libel is written defamation. It ends with a person's death. Apparently, you cannot defame people that are dead, even though their heirs may think otherwise. Truth is an absolute defense to defamation of character. So it has to be an untrue statement made about the plaintiff and being published. That means even if it was untrue and it was negligent, we're going to talk about negligence, the person didn't know it was untrue, but they stated an untrue statement. The person can be liable for defamation. The Supreme Court came by in the New York Times v. Sullivan case and held that public figures must prove actual malice. It cannot just be somebody carelessly giving an untrue statement. Actual malice means knowingly or with reckless disregard to its falsity. They have to know that the statement is false. See the sidebar on 10.3, page 288, for further discussion on this. Okay, fraud. Now, we talked about fraud in contracts. There, if a fraud takes place in a contract, if you remember, it was a voidable contract. It means a person could continue through with the contract if they wanted, the one that was defrauded, the lie was given to. But they did not have to. In that case, there was no civil penalties. It was that the contract, the other party was, the contract was made void and they didn't have to perform, would get back any consideration that they had given. So under tort law, a misrepresentation of a material fact is fraud. The person that states it must have knowledge that the statement was false, and the intent to deceive is called scienter. Was also recklessly disregarding the truth. So there was an intent to deceive. They made a false statement. They knew it was false, and they wanted to deceive the other person. And the plaintiff reasonably relied on the misrepresentation. If there's no evidence that the plaintiff relied on it, there's no fraud. And finally, the fifth element is the plaintiff was injured. All 5 elements must be there. How do you prove somebody's intent? That's for the jury to decide. They look at all the circumstances around it, they look at it, and they make a reasonable conclusion that the facts, the evidence that was before them showed that the person did intend to deceive. That's what lawsuits are all about. Okay, misrepresentation versus non-disclosure. Fraud does not always require misrepresentation. The defendant has a legal duty to disclose. The sale of real estate, for example, if you know that there's the roof is about to fall in, you have a legal duty to disclose it. And so it can be misrepresentation or fraud if you know that and do not disclose it. Fraud in the concealment. See Wells Fargo Bank versus Arizona Laborers, Teamsters, and Cement, case 102, page 289. It was an Arizona Supreme Court case. This was a non-disclosure implies a duty to speak. Active concealment does not require such a duty. So sometimes the non-disclosure is a duty set out by law, but if you can show that there's active concealment, then that falls into the fraud, the misrepresentation, and it does require a duty not to actively conceal. The facts of the case, the plaintiff was not required to establish an affirmative duty to speak in order to prove fraudulent concealment. Actions by the bank, which intended to conceal material facts, are, if proven, sufficient. This was a case where the bank had a takeout loan on its construction loan, and they did everything they could to keep the takeout lender from knowing that the borrower was actually in default. They deliberately did not put the borrower in default, which they normally would have done, because they wanted the takeout lender to pay off their construction loan. So also look at fraud in the inducement, Campbell v. McClure. So is it a tort or a crime? Well, maybe it's both. Both crimes and intentional torts involve intentional action. You look at a lot of the criminal cases that come by, they're followed by civil cases for assaults and batteries and things like that. Crimes are often intentional torts that are made criminal by the legislatures. Different burdens of proof for torts and crimes. A tort must have the preponderance of the evidence. It's for a jury to decide who is liable and not. Crimes, the person must be found guilty beyond a reasonable doubt. Civil actions, torts, allow the injured plaintiff to recover damages. Criminal, they go to jail. Common law torts, the intentional interference with contractual relations. Watch out for that. You can't go in and induce somebody to break a contract. Pennzoil case of 87, there was a $10 billion award against Texaco for persuading Pennzoil to breach an agreement. Fascinating case. Take a look at it sometime. Okay, I'm going to go on with part B under negligence. So answer your forms, and I will talk to you later.